Hey everybody, and welcome to MyHR Live number 26. Hopefully today without any technical issues. So again, I apologise for last week. That was a bit random. I think I'm right in saying we might be exploring another platform. We've had a few questions for people who are not on Facebook who would like to be able to view these live, and we're just finding with the Facebook app it's a bit up and down sometimes, and last week was case in point. So I do apologise if you had scheduled time out of your busy days to watch this last week and then you missed out. But looking forward to diving back in. Usual format for the live events. This will be recorded. It will be posted on our YouTube channel, Facebook page, LinkedIn page, or via our own website at myhr.works. And yep, .works is the URL extension. We have transitioned since the last time I talked to you from .co.nz to myhr.works, which is a universal domain and signals our formal launch into Australia, which is super exciting. So if you've got any businesses or mates businesses over there, let me know. We have a growing team of experts in that jurisdiction and some really interesting legal things happening over that side of the Tasman too from an employment law point of view. Of course, ask questions today in the live event and I will do my best to answer them. If you're watching the recorded version of this and there are some things that you want to check in on or ask about, please get in touch with MyHR and feel free to ask those questions. So thank you, and let's kick in, hey? So today's topic is, somewhat, I guess, a curly one. It's the sort of thing that not a lot of people like to talk about, but at MyHR we do, and we'll talk about anything because we think in any situation related to employment, behaving like a good human is really what's going to get you through. So today we're focusing on termination, and termination is a fairly broad topic, but it's termination of employment. Really, I want to pick up on a bunch of different ways an employment relationship can end that we haven't covered before. We've done dedicated sessions in this format on 90-day trial periods, on redundancy, I think on medical termination. We do have a pre-asked question about medical terms, so if I've got time, I'll pick that up. But today is more just a bit of a pickup of all the other ways an employment relationship might end. And I guess if things come out of that, we could do a more focused event in the future. Leading into this, one thing I have noticed, because redundancy is not on the cards for today's chat, we've covered that previously, but this is just a watch out for people who sort of think that maybe redundancy is a shortcut to ending an employment relationship where there's a person who's not performing and they don't want to go through a disciplinary type process, or people who think that a shortcut to exit and then maybe we look at, paying some money as a settlement, a $5,000 sort of pay to go away type thing. That thinking now is really flawed, and we are pushing back against it as much as we can. And there was a case published last week, that really hammers this home. It was a tyre shop in Christchurch, and he ran a redundancy process for an employee. The process was challenged and found to be flawed, and the payment to the employee from the employer, as ruled by the Employment Relations Authority, was $145,000. And this is in line with a trend of increasing settlements being awarded at the authority. So it is really flawed thinking to go into these processes going, I can just shortcut what the law requires and maybe pay a bit of money and make the thing go away. I guess for some organisations, 145 grand might feel like small change, but for a lot of us, $145,000 is a decent whack of money. Not to mention, of course, the legal fees on top of that and all of the time out to deal with and manage that case. So it's just a bit of a watch out more than anything else. The process is there for a reason. The law is pretty clear. So, let's do the right thing is really the answer there. So terminating employment, there's two categories here that I'll cover. One is employer-led and one is employee-led. So employer-led termination is when the employer pushes somebody out of the company for a reason. Employee-led is when they leave you. They offer to resign or retire or whatever that may be. So employer-led, I'm going to be talking today about dismissal on notice, so following a series of warnings, summary dismissal, which is sometimes called instant dismissal, probationary periods. I'll talk about resignation during disciplinaries because that can be seen as constructive dismissal. And then in terms of employee-led, we'll talk about resignations, abandonment, retirement, and then I'll have a bit of a chat about final payments. We have had another question as well. I mentioned the medical term one, and this is a particularly contentious topic, but it is something, again, I'm not going to shy away from and would like to talk about. And the question's quite loaded, but I'll address it and we'll talk about it at the end, and it's around terminating for mental health. So, we are certainly seeing increases in rates of anxiety, depression. The mental health statistics are quite alarming. And this is something that I think we need to deal with and address. And I think there's some concern or questions from employers about terminating on the basis of mental health, and there are some things that you should definitely not be doing. So that is also a topic we'll try and fit in at the end. So let's dive into employer-led termination reasons, or employer-led termination. So before we define which type of ending of employment you are doing, two things that the law is very clear on and you need to keep in mind at all times. One is you need a good reason for ending employment. That is what is called the substantive justification. Why are you ending the employment relationship? In the case of redundancy, it's a genuine commercial reason. In the case of conduct or misconduct or serious misconduct, it is an action that has in some way damaged trust in the employment relationship, damaged the reputation of the business, caused loss in some way. In cases of performance, it is a version of sort of repeated poor performance where the person is not doing what they've been hired to do. But the reason must be justifiable, fair and reasonable, right? And that is your substantive justification. So that's the reason that you dismiss somebody. Fair process is the second point. And in New Zealand law, typically substantive justification and fair process are weighted pretty closely together. So there are some jurisdictions, and Australia is an example, where if the substantive justification is really clear, the process steps to getting to the termination don't have to be as rigorous. That doesn't work here. You can be found to have an unfair dismissal if you have not followed the right process in reaching your outcome, even if the behaviour of the individual was pretty clear cut. In an award settlement type scenario, the Employment Relations Authority may factor in a contribution amount and reduce your payout a bit based on employee contribution, but you won't be off the hook. So fair process or procedural fairness is the other part. So good reason, fair process. Substantive justification, procedural fairness. Those are the sort of more technical terms. You must keep those two things in mind at all times. And so then if we move into the most, I guess, emotionally charged type of dismissing somebody is summary dismissal. Summary dismissal is sometimes referred to as instant dismissal. I think that's a bit of a misnomer because there's nothing instant about it. There is still a process to follow, and the process must be followed. Summary dismissal will occur as a result of something we call serious misconduct. Again, another term that has been used to describe it is gross misconduct, and that's okay. Serious misconduct, gross misconduct. It seriously undermines confidence and trust in the employment relationship in some way. People often ask me for examples of, and you can give some broad categories. There are some things that clearly are, like major breaches of health and safety, breaching the drug and alcohol policy or being on drugs or impaired at work, which also has a health and safety effect. It might be theft from the employer, those sorts of things. Harassment, sexual harassment, bullying, these are the sorts of things that fit that category. But where I get nervous about categorizing things is every situation is different. Every event that occurs that might prompt you to think this is a matter of serious misconduct requires some level of investigation and understanding before you reach an outcome or reach a determination. You can't just make a blanket assumption that this one thing will always result in dismissal. So doing a thorough investigation is critical when it comes to matters of serious misconduct. Having good policies and clear policies around the sorts of things can help, but it's not always, it doesn't always really necessarily help, particularly if you have a statement around what constitutes serious misconduct and the behaviour doesn't quite fit that, but it is close enough to. It can often just cause some confusion. It is clear generally when something has seriously undermined the confidence and trust in the employment relationships to an extent that the employer is considering terminating employment. and then the evidence from that investigation will be presented. I have seen policies that aim to kind of capture all the potential types of serious misconduct, and then every time there's a dispute or a disciplinary in the business, they add another line, and you end up with this ridiculously long bullet pointed list of all of the things that constitute serious misconduct in the business. It gets a bit unwieldy and it's not really necessary. But yeah, breaches of health and safety, being impaired at work, like on drugs, taking drugs and those sorts of things. Theft is common. But of course you need to establish that these things have occurred, whether it's through drug testing or through a reasonable observation of impairment, and that is in some way sort of verifiable by a couple of witnesses or more, or that the theft or the taking or the misappropriation of company property has also genuinely occurred. And this is the importance of investigation. And some examples, as you know, I like to use real life examples, but some examples of things that I have seen in the past is where an employee was loading pallets from the warehouse into a van and was seen taking them home, and a manager witnessed this, was very upset, contacted the HR department, was adamant that this employee was stealing and was intent on running a process geared around theft and serious misconduct and summary dismissal. And had that been allowed to run, that would have been found to be unfair, because on investigation we found, of course, that the warehouse manager had said to the employee they could have the old pallets and take them home and use them for whatever, kindling or something or other, storing stuff at home. So it wasn't a case of theft at all. The employee had been given permission to take company property away for their own personal purposes. And that's the critical thing to an investigation. The tricky ones, of course, are where there are complaints about individuals, bullying, harassment type complaints, and there might be different versions of events. A couple of things that are really critical in this is anyone who's implicated in any of the complaints cannot be involved in running the investigation, right? And this can be particularly hard for small or medium-sized businesses, but you need to find a way to remove that person. So where there is a dispute between manager and employee, or a claim of harassment, and the manager is the person who has been accused of doing this thing, or the manager is accusing the employee of doing the thing and they don't have a particularly good relationship, the manager's part of that investigation, so should not be the one to run the investigation. So if you don't have an organisation that's big enough to allow that to occur, you might want to think about engaging some external support to do it, because the person leading the investigation is potentially conflicted in any findings because they have a part to play. But there is always a process to follow, right? No matter how serious, no matter how full on, no matter how obvious it is, and some of the things, as you can imagine, over my career I've dealt with, are quite blatant and quite full on, from people, from assault, and the assault was captured on CCTV and witnessed by everybody, and it was very clear that it had happened. None of these things allow you to just walk in and say to somebody in that classic TV style, you're fired. It doesn't work like that under New Zealand law, and I would encourage you not to do that. You must still conclude and investigate, or conduct an investigation, share the findings with the employee, propose the outcome that is potentially dismissal, hear from them, consider what they have had to say, and potentially investigate further. So that's serious misconduct. Dismissal on notice is a series of warnings. So how do they differ? Well, summary dismissal doesn't have to have any prior warning. It can be this one act, one piece of behaviour, and you're gone. When you are confirmed as being terminated, you leave at the end of that meeting or the end of that working day, however you manage it. You are not entitled to your contractual notice period. You get paid hours up to that meeting, and you get paid annual leave accrual. Dismissal on notice relies on a series of warnings: formal, final, and termination. So that three strikes process is pretty common. The law does not tell you how many warnings you have to have. Again, the law just requires that it is fair and reasonable, and that there has been a reasonable opportunity for the employee to improve. A couple of things about dismissal on notice and this compounding warning piece. Warnings can compound for different reasons. So there's often a misunderstanding we encounter that if you've been given a formal written warning for, say, repeated lateness, and then you do something that causes a customer complaint, that's a different matter and requires another formal warning. It's not the case. You can issue then a final written warning for the customer complaint if it is upheld, because there is already a formal written warning in place for repeated lateness. And so you're talking about the compounding effects of poor performance or poor behaviour by the employee, and they all count towards that potential dismissal outcome. You can imagine that otherwise you potentially have a formal warning for lateness, or one for a customer complaint, or one for doing something silly, whatever it may be, and they all sort of build up and paint a picture of an employee that's not particularly good, but you're not progressing. The key things with this is when the warning is issued, there should be a performance improvement plan. It should be really clear what the employee needs to do to improve and how they're going to get better, and you should offer support and training to allow them to do that. When you reach the point of termination, if it hasn't improved, that is dismissal on notice. So they are entitled to their 1 week, 2 week, 4 week, 12 week notice period. Often we recommend that you just pay that out. It can be difficult having an employee around who knows they've just been dismissed, and it's often easier just to meet your contractual obligation by paying out the leave. But if you really don't want to do that, then yep, you can compel them to work. If you compel them to work out their notice and then they just fail to turn up or walk away on you, well, at that point you don't have to pay notice because they've refused to work it. I have encountered some employers that try to do that in a way of sort of calling the bluff. Again, I think that's just a bit silly and a bit, what's the word, a bit kind of spiteful almost, and sometimes the bluff calling doesn't work. The employee attends work every day of their shift for their notice period, and they're actually quite difficult to deal with. And it's very awkward, and it's very difficult to run another disciplinary at that point because they're already on their way out. So my view is you pay out the notice period and kind of cut ties, and away you go. One little watch out with termination in either event is there is this requirement if you reach that decision to propose termination first, and then to pause so the employee can consider whether or not they believe termination is fair. That can be a bit of a weird process for anyone who's actually conducted a disciplinary meeting that results in termination. Logically the employee is going to say, I don't think it's fair at all, I think it's terrible, don't sack me, this is a horrible situation, which you then have to consider and then confirm the outcome. But this step can catch out employers and it is often missed or ignored. So those are the termination types. If somebody puts a resignation on the table during a dismissal meeting or a summary dismissal sort of process, serious misconduct process, or during the series of staged warnings, I caution you to be very careful about accepting it. You may want to kind of jump over the table and go, yep, this is great, I don't have to go through a difficult process, they've resigned, happy days, see you later, bye. That is potentially justification for a claim of constructive dismissal. Which is when you've made the situation so bad at work that the employee has no option but to resign. So you haven't come out and said outright, I'm going to sack you, but you've made it so awful for them that they're going to have to quit. Or you're running a disciplinary process where the outcome appears to be so predetermined that I feel as the employee, my response is not going to be listened to, I'm going to be sacked anyway, so here's my resignation, right? And if that's the case, that is a flawed process. So an employee who tries to resign too early may be doing so because they believe there's a predetermined outcome. I strongly encourage you not to take the resignation immediately, to explain to the employee that you are committed to a full and fair process, that you want to listen to their response, you want to consider everything before making a final decision, and resignation is not the only option available to you. And then give them 24 hours to reconsider. If after that they still confirm and they say, no, I know you haven't made up your mind, I just don't want to go through the process. In fact, I'm going to take this opportunity to leave town, I'm going to move back to my hometown, see you later, here's my resignation. Well, it's a little more robust at that point. But an outright sort of resignation, or we're still encouraging them to resign instead of going through the process, can land you with a claim of constructive dismissal. So racing through now, the last one around that employer-led termination is just the probationary period, which of course, since we've lost the trial period for 20 and over employees, has become more of a thing. And just really quickly, what on a probationary period and what does it mean? Well, it's not the same as a 90-day trial period in that it doesn't give you the protection from personal grievance like a 90-day trial period. What it does do is it sort of fast tracks you to the conversation about the end of employment. So if for example, it might be a way, it's not a very positive way of looking at your first 3 months of employment, but it's almost like you are being hired on the final written warning, right? So you're already at the stage where if you kind of don't perform to the standard that the company expects, they can engage in a consultation process that results in the ending of your employment because there is a probationary clause in place. It does not mean you don't consult. So you must consult in the same way you would consult on any other disciplinary matter. You must also be able to demonstrate that you provided them all of the adequate training and support they needed to do the job well during the probationary period, that they were aware of the standards. So if it's a behavioural issue or a conduct issue, that they were aware that that behaviour or conduct was not accepted. They've signed a policy code of conduct or attended an induction training, that sort of thing. You're not protected from grievance. One can still be raised, but a good solid process and a decent probationary period in the employment agreement will help you if the process is challenged. Unlike trial periods, probationary periods can be extended. So let's say you have a 3-month probationary period and you get to the end and you're going, you're okay, but there's some improvement areas, I'd like to give you another month to improve. You can extend the probationary period. You cannot do that with 90-day trials. So there we go. That's a quick fire of kind of all those other bits that we haven't covered in previous issues around termination. Employee-led terminations are pretty obvious, right? One is resignation. I quit. Here's my letter, see you later, bye. Or sometimes not a letter, sometimes a phone call or a text. So how do we handle resignations? What are the obligations on the employee, etc.? So there is, of course, an obligation to provide the contractual notice period that you are bound by. That's most commonly 1 week, 2 weeks, or 4 weeks. Some positions, some more senior roles or hard to fill roles will have a 6 or even a 12-week notice period. And some very senior roles I have seen have a 6-month notice period. There's a double-edged sword there, of course, because if you terminate someone for poor performance, you might be obligated to pay out a 6-month notice period on conclusion of the process. So when they resign, we always request it in writing. Good employment agreements will ask that the resignation is received in writing. People don't always do that. They might sometimes just ring and go, actually, I quit, I'm not coming back. I encourage you, if you do that, to write back to the employee so you have a written confirmation of resignation. It just avoids ambiguity, right? And so you write back and you say, hey, further to your phone, dear Jason, further to your phone call, at 3 p.m. on Monday, you phoned from your parents' house in Wellington to tell us you won't be returning to Christchurch to attend your work anymore, that you've quit your job because you want to stay in Wellington. I therefore confirm your last day of employment is today, or was that day, whatever day that was. You will be paid out any accrued annual leave that is owed to you, but you forfeit your entitlement to your paid notice period. And then you've got the written record at that point. It just kind of rounds things out nicely. We've had instances of kind of phone quit, resignations, and then the employee turns up a couple of days later having changed their mind, and there's no real conclusion, and it's a really awkward position to be in, and you're potentially at risk of a claim if you then just say to that employee, no mate, you quit, forget it, see you later, bye. I like, for the sake of completeness, to have that rounded out. Text messages, not ideal, but it is written communication. Save the text. I would also encourage you to write back on that one. Abandonment of employment is the other one. Most employment agreements will say that if the employee has been absent from work for a period of 3 days and has not made contact, that they will be deemed to have abandoned their employment, and their employment will end automatically at 5 p.m. on the 3rd day. We often get abandonment requests, or I hear people asking about abandonment in situations where, say, an employee's been on sick leave for a few days and they're sort of not coming back, or they were expected back. They've rung up and said, oh, look, I don't know when I'm coming back, it's a bit loose. And they go, well, this is kind of abandonment of employment. They haven't given us any situation. That's not abandonment of employment. Any contact from the employee, if you know where they are, then it is not a case of abandoning employment. They've let you know. Now, they may not have let you know in the right way. You may need to consider another form of termination that is in breach of their agreement around a misuse of sick leave or extended time off work that results in medical termination, or whatever it may be. It doesn't mean you can't terminate for that failure to regularly attend the shift. Just don't think you can always call it abandonment of employment. It's quite a narrow definition. So genuinely, someone is completely out of contact, and you can demonstrate you've made attempts to contact them at least on each day. Most commonly, I guess the thing we see is it's kind of day 7, and employers go, oh, I haven't heard from this guy for a week, I've been trying to ring him, can I do the abandonment now? And you can, but sometimes if you let it go too long, then they reach out and make contact, and then it's no longer abandonment because you now know where they are. So just get your processes clear. Day one, no contact, hasn't attended their shift, don't know where they are, make a phone call, make a note. I rung, it went to voicemail. I rung his emergency contact just to make sure that he wasn't hurt or injured or lost somewhere, hadn't come back from a hike or whatever it may be. Emergency contact had no idea. I wait, day 2, same again. Day 3, same again. At 5 p.m. on day 3, in accordance with the agreement, termination occurs. We again recommend you wrap that up with a letter saying this is what's happened, here's the contact attempts we made. We are proposing to terminate your employment in accordance with the abandonment provisions, and you allow that opportunity for them to come back, but you're effectively concluding there, right? So that's abandonment, and then there's retirement. I'm going to talk about final payments in a moment too, by the way, because I know there's always a question about deducting from final pay. Retirement is just kind of another form of resignation, right? And a question that we do sometimes get is, can you force somebody to retire? New Zealand doesn't have a statutory retirement date, so telling someone to quit based on their age is age discrimination, and so you can't. So you might get the pension at 65, but that does not mean you have to retire from your job at 65. So if you have concerns about an employee's performance, you can still manage that. If the performance concerns are related to age, you can address that. But you can't simply decide that at 65 or at 72 or whatever the age may be, that someone is now too old to attend work. It doesn't work that way, and that is clearly a discriminatory practice and in breach of employment law. But again, this does come up. It is a bit sensitive, and as I get older, I'm mindful of it too, as my own brain starts to wander or whatever it may be. But employers will contact and say, look, he's just not as good at the job as he used to be, and there's some issues with health and speed, and I'm concerned about health, and they may be age-related issues, but you need to articulate those in an objective way that clearly relates to performance in the role. So there's a quick fire around employee-led exits. The final payment piece I just want to touch on, and it's around deductions. So deducting from wages changed quite dramatically under, was it the last revision of the Employment Relations Act and the Wage Protection Act, or the one before? I can't remember now. There've been a few in the last few years. But anyway, deductions from wages are now a little bit harder to do, right? They require more consultation with the employee. There is this practice, this historic kind of thing of these employment agreement clauses that say, if you resign and do not work out your contractual notice period, we can deduct an amount equivalent to your contractual notice from your final pay. That in itself, if applied correctly, is not illegal, but I strongly recommend, and this is my recommendation, so it's an opinion, please feel free to challenge me, that you don't bother with those clauses. They're actually largely unenforceable. You can deduct from final pay, and if the employment agreement says we can deduct from final pay an amount equivalent to unworked notice, you have an agreement, a contractual agreement to do that, you still have to demonstrate that you are deducting from that final pay to cover other costs that you have incurred as a result of the resignation. So that might be additional contract labour or temporary labour to come in and cover. Maybe it's loss of revenue from a job that fell over because the employee walked out. Most of the case law around this, and I don't have the one in front of me that I can quote, but this idea that clause just allows you to kind of unilaterally take 4 weeks' pay off an employee if they quit and walk out on you. That is flawed thinking, and the case law supports that. There are a number of cases where the authority has quite clearly ruled that the deduction was unlawful. The employer has been required to pay it back, and generally in those cases when there's a requirement to pay that back, it's the trigger for a broader grievance, and there's some payment for hurt and humiliation and those things. My view personally is that if you have to penalise a person to force them to stay with you, you might want to just look at the quality of your workplace and the culture of your organisation, because a person who's working out their 2 weeks notice for fear of being fined for not doing it isn't going to be a particularly engaged employee. A person who is willing to walk out on their workmates and leave them carrying work is not necessarily the kind of person that you want in the workplace anyway. So forcing people to stay, I don't ever think is a good thing. Much better that people want to stay, and then if they resign for genuine reasons, they're willing to give you their proper notice period because it's the right thing to do, and they are good people. So in a final pay, what do you pay out? You pay out the wages that or salary for the hours worked. A notice period you either pay as you go if they work it out. If you don't want them to work it, you pay in lieu of them working. If they refuse to work it or say they're not going to work it, you do not have to pay the notice period. You pay annual leave, and that is the available balance, so that is paid at the greater of average weekly earnings or ordinary weekly pay, and you pay the accruing balance, which is 8% of gross earnings for the current anniversary period. Sick leave does not get paid out. Other forms of leave like domestic violence or family violence and bereavement and things like that are not paid out as well. Alternative holidays are paid out. Alternative holidays, as you know, are the days in lieu. So you've worked a public holiday and you've got a day in lieu or an alternative holiday there. And then maybe any other contractual or policy entitlements you have in play. Time off in lieu that they have accrued. Maybe there are bonuses and things like that. So you have to be aware of your contract or your employment agreement, and what's contained in that. Okay, folks, so that's our 30-minute session. We try not to go over there. I haven't addressed the mental health issue, but I think it's such a sort of curly one. I'm going to suggest we might pick this up as another live because there's so much going on in this space right now, and I'm thinking I might even bring in an expert and we sort of have a conversation about that. Before I do sign off, though, what is worth sort of dealing with is any questions that have come in. The medical termination one we had, there is a previous live on this that would be worth watching. In terms of medical termination, there is again some case law around this. One of the famous quotes in relation to an employer who terminated an employee who had been incapacitated and off work for a year. The employment court judge said something along the lines of there comes a time when an employer can reasonably cry halt and terminate the relationship. What we encourage is that you have a medical termination clause in your employment agreement, because if you don't, the case law suggests that you need to wait at least 12 weeks. So it's like 12 weeks or 3 months where an employee has not been able to attend work. You can then look at triggering a discussion around that medical termination or incapacity type termination. Whereas if you have it specified in an employment agreement, you can have a less time. You can have a contractual agreement that says incapacity of 6 weeks could result in this. So a strong employment agreement is really helpful. I would recommend that. But again, it has to be fair and reasonable. You know, if you think about people are entitled to 5 days sick leave a year, maybe 10 soon. We'll talk about that again at another Facebook Live or MyHR Live. But you know, if the law allows for 5 days off a year and allows you to accumulate up to 20 days, really anything less than that is probably seen to be unreasonable in terms of affecting a medical termination. So that's probably a good baseline. That's certainly where we start, and we look beyond a month off work before we will trigger consultation around medical incapacity. So I hope that helps you in some way. What other questions have we got?
A few. So Employment New Zealand states the following: a warning for one type of misconduct cannot be relied upon when dealing with another type of misconduct. That seems to be at odds with what you said before. Okay, so I don't know if you heard what Isaac mentioned there. It said Employment New Zealand states that a warning for one type of misconduct cannot be relied upon for a warning of another type of misconduct. So, and that which appears to be at odds with what I have said to you. So I think that is a case of the wording of how Employment New Zealand has worded that. So relied upon, right, means when you are, if you are saying, if we use my example, I'm the late guy, I got, repeated lateness, and my boss sat me down and I had the letter and it was repeated lateness. I didn't have a reasonable explanation. I got my formal written warning, and I'm now sort of have this formal written warning on file for being repeatedly late to work. I've got a performance improvement plan in place, which I have to buy an alarm clock or whatever it may be. Okay, and then a month or 2 months later, I do something that triggers this customer complaint. I'm rude to a customer. Not to the extent that it's serious misconduct. I haven't sworn at them or abused them, but I've been rude, and it's rude enough to be a breach of our customer service standards, and rude enough to mean that we have a customer complaint and perhaps we've lost a customer. That can trigger a warning. I would absolutely make that a final written warning on the basis of the formal written warning that has occurred in relation to lateness. But I am not relying on the content
of the first warning to justify the second warning. So because you have a formal written warning on file, because you've been late in the past, I hold that you are also a poor performer generally, and that poor customer service this complaint is upheld. I'm not relying on that to inform the outcome. I am investigating the customer complaint on its own as an isolated issue. I am determining that the customer complaint is upheld. I've listened to the employee's response and said, yeah, you haven't really given me any satisfactory evidence to the contrary, and in fact it was a phone call, so we have that recorded in our phone system, and we can clearly hear you saying some nasty things that are in breach of our policy. I have relied only on the available evidence in relation to that thing, and I have concluded that misconduct has occurred. I now need to consider what warning outcome I issue for you, and we've established it's not serious misconduct, so I can't sack you, but I can issue you a warning for that. Because you already have a formal written warning on file, I am now issuing you a final written warning. So I get that might sound a bit like legal semantics, but the reliance on the lateness issue has not informed the decision around the customer service issue. But if you do not do that, as I said earlier, you will then have another formal written warning. So you have two formal written warnings. Let's say the following week I do something that is unsafe, but not to the extent that it's serious misconduct. I just leave a mop lying around or something, again, in breach of the safety policy, could have caused an injury. The employer does the investigation and determines there's a policy breach. It's a matter of misconduct. It therefore justifies a warning. I can't rely on the customer service issue or the lateness issue, but if the way you've interpreted employment law Employment NZ goes, the employee now has a third formal written warning on file. So they're late, they're rude to my customers, they are unsafe, and they're still only on the first stage of their warning. And you can imagine that potentially compounding. That is not the mechanism for how the law works here. You need to determine those things in isolation. Past behaviour doesn't necessarily rely on future behaviour to make that happen, but you can compound the warnings. If you disagree, totally challenge me, write in, because I'm keen to sort of get this right. But this is a practice that is fairly widespread. So yeah, I'm fairly confident about that. Of course, where the performance compounds and it is linked, so I don't know, let's say I'm a sales rep, I've been hired to hit a number of targets and I continuously fail to do that, and I'm not even getting close. I've done all the sales training, I've had all the product training, I've got everything, all the tools available to me, and I'm still not doing it, and the employer reaches a point of frustration. I get my formal written warning, they set some new KPIs, I don't improve, I get the final written warning based on my failure to improve on those standards that were set from the formal to now, and then I have my final, and then it's final to dismissal. So I hope that makes sense without being too legally complex. Another question?
Are you saying that if an employee sends a text to quit with immediate effect, being a full-time permanent employee, the notice period should be taken out of their holiday pay?
No, I'm saying you should not take the notice period out of their holiday pay. Yeah, sorry. Maybe I need to repeat the question. I don't know if you heard Isaac. The question is, am I saying if an employee who's a salaried full-time employee quits over text with immediate effect, should I be deducting their notice period from their holiday pay? I'm saying no, that you should not be doing that. What that employee is missing out on is the notice period that they've refused to work. So you have a contractual obligation to pay them 4 weeks notice, I'm assuming. They've forfeited their right to that contractual obligation because they've quit with immediate effect. You pay them if they've worked that day and then text you at the end of the day, you pay them for their wages or their salary, up to that day. If they're currently on leave, well, you pay them the leave that's been approved, and then any owed annual leave, alternative holidays, time off in lieu, or bonuses in accordance with your policies. Any deductions from that final pay need to be justifiable. So if they owe you something, if they've damaged the car or the computer or whatever it may be, I'm warning you against those clauses in the agreement that just appear to allow this unilateral deduction of notice period from holiday pay. That's dangerous. If that's challenged, it is most likely that the employer would lose the challenge. So sorry if that wasn't clear. What I'm saying is the opposite of what the question asked.
Last one. What do you suggest for wording instead of the list in Code of Conduct?
What do I suggest? Okay, so that question, it's a really good question. So what do I suggest for wording instead of the long list in the Code of Conduct? So this relates to that serious misconduct list I mentioned. What I recommend is a condensed list that sort of covers categories and a broad statement that is along the lines of serious misconduct is an issue or a matter or a behaviour that seriously damages or destroys confidence and trust in the employment relationship. This can include, but is not limited to, and then you would say things like serious breaches of established and agreed company policy. So suddenly health and safety policies in there, drug and alcohol policy, company vehicle policy, and it's about a serious breach. You might say then specifically you might go into a breach of the drug and alcohol policy if you want to put that. A failure to follow reasonable instruction to the extent that it causes risk of harm or harm to self and others. Behaviour that seriously damages or creates risk of harm to self and others. So you're sort of capturing some broad categories. If I think about behaviour towards other people, so there's anything that might capture the bullying, harassment type thing. Health and safety, absolutely. Maybe drug and alcohol conduct if that's a thing. Theft or misappropriation of product. Maybe fraud or actively or misleading the employer. Those sorts of categories. Rather than saying that some of the ones I've seen say lying on the expense claim and then taking stock from the warehouse without permission, and all these things might be serious misconduct, but these very granular descriptions become these lists of the 50 things, which can sometimes be counterintuitive. And if you've watched my other Facebook Lives, you end up in a situation where the policies are so long and so complex, they're not read and understood, and you can't reliably demonstrate that they've been understood. Employees who have a 150-page code of conduct to go through, and you're then disciplining them for failing to do something that is in paragraph 4 on page 78. It needs to be plain language, clearly understood by all people. So that's my recommended wording is around that. A catch-all statement and some category bullet points. Hope that helps. Any other questions? No other questions. So thanks again. That one went a bit over time, but yeah, kind of a curly one, and we tried to catch a lot in there. Thank you for those of you that watched live. If you're watching this recorded, thank you, and look forward to any future questions. Take care, everyone.